the first to know Nsem-Pii TV.
Ebusafo yedasoa ewo eye Chief Justice get to Torkonoo ene John Dramani Mahama ensensem ya emu. Na sese no de asem no eya akeka koro ne de no kura nim ni. Eho besi hia se asem no se ne oman Ghana mu akwa ne be free kura na no kura e be free. Na ba bia wo se ekọ na ibetimi ama pepepe ye atodwa no atimi ato. In fact ene Kwaku Ansa Asare eye the former director ewo Ghana School of Law ene Kwaku Pencil a private legal practitioner and the lawyers a kuku dama wo man Ghana mu ha ana chese o maka mutira aboma o mo chese ade na John Dramani Mahama eye wo judiciary no eso no kre ehun behia se o mo de no epe baabi ede ne fa na o ma emra eto de emra edi yen ani twa se eye committee a e probi eye Chief Justice get to Torkonoo the remover no enu ada onum ko asetena na anche ana chese Chief Justice get to Torkonoo enso so e file injunction bi against the committee probing her removal. Say, in fact, one, the osu enye probing na mo regarding the removal no. Omo man enye in camera, public hearing. Say ye be na bibia ye fair na yankotwa in church ye bia ewo baabia. Ana etosu bi no. O say the prima facie case against her no de bia ye improper, unconstitutional, null and void. And at the same time, osanso kan bi say suspension of Chief Justice no infringement on the judiciary. And no anachese lawyers e wo oman Ghana mu ha ejitum say sa injunction suit Chief Justice file against the committee no de bia eto asomo no munnim de enti a Supreme Court rejected sa injunction suit no. Na in fact omo chese John Dramani Mahama de all ye no pese wo to judiciary no eso emomu sese no ne nsa edaso no de bia betimi ha oman no in the future into a lawyers a woman Ghana mu ha no a omo ka bia ewo no omo nyina kan homo na omo pe ba bia asem no fapem esie na omo ntimi take the necessary action against the government John Dramani Mahama na ene Kwaku Pencil ene Kwaku Ansa Asare akansem regarding the Chief Justice get to Torkonoo the injunction suit no yentie Nsem-Pii for the agu apono so.
Interesting, very challenging and very engaging because it is actually an attempt to get the Supreme Court to reflect upon our Constitution at the time that it was made, developments that have transpired thereafter, and whether the Constitution must be steeped in the grounds of 1992 when all these issues of internet and diverse information wherever was hardly an issue. And now, when you file a process, it is transmitted worldwide. And against the background of the supposed secrecy that processes and proceedings in the courts were supposed to be conducted, against now that you file a process, everybody hears whether indeed there's a continuing need or justification for us to bind ourselves with the constitutional dictates or the requirement which intended that certain things must be done in utmost secrecy until the outcome or the results or the judgment. So that's the issue that is really now engaging our attention, whether there's a justification for anybody insisting that things must be done in camera when before the camera hearing everybody knows what is outside. It's a joke. I mean, that's my view. It's a complete joke for us to pretend that in the era that we find ourselves, anything can be done in secrecy at all.
That anything can be done in secrecy, but just because you made mention of that point, what does the Constitution say?
No, the law is clear, at least it's found in the Constitution. I'm not quoting provisions and whatever, but I'm very familiar with these things, that this type of proceedings ought to be heard in camera. And by camera hearing, it means that beyond and besides the persons and the judges who are directly involved, nobody must see the processes, nobody must comment on the processes, nobody must have a way of knowing what is going on, kind of. But that's very funny if you just oppose it into this, realities.
So do you think the existing realities, just before Sweetie comes in, the existing realities would be conducive for a public hearing of this nature,
I believe
especially
so.
as
I honestly believe so, because everything is out in the press. Everything. Everything. So therefore, the pretense or the attempt to have an in-camera hearing is a joke. I mean, it's a joke. It's something that we are all pretending about. And I honestly believe that the request by the Chief Justice to have this matter heard, for everybody to know what is going on, to bring out into the public domain everything. So that at the end of the day, justice is for the people and by the people. Justice is for them. Everything that we do in the court is intended to buttress and to deepen their faith in our democracy. And indeed, I mean, the traditional rule against public hearings, where in matters that affect public decency, in other words, I mean, sexual, whatever, suits and the rape and things like that. But even now, judges are hearing some of these things in the public. I mean, everything has changed over time. And I think that at the time that the 1992 Constitution, we may go back to 1992, see the background from which we came from and all of that. And in 1992, I don't even know, I don't believe 1992 I was an adult. I don't believe there was anything called internet. I don't believe there was anybody who contemplated, anticipated that time is going to come that anything can be broadcast from America to Ghana through, I mean, text and stuff like that. So, to the extent that we have a constitution that captured the events of 1992, it's about time that we told ourselves that any attempt by anybody to hold on to the forms and the substance of things in 1992 is a big joke. I mean, that's the long and short. And I understand Dami's application to reflect this sentiment, this feeling, that it's about time, even if the Constitution said it, everybody knows what is going on. Everything has been published. Look at the commentary. Indeed, as a matter of law, even all the publications that the people are making, it's against the constitutional provision itself. So what is the pretense? I mean, why do we say that these things have to be done in camera when everybody is commenting, everybody is talking about it, when even matters that are in court, traditionally, they are not for public discussion. They are not for public commentary. So what is it that we cannot do by not hearing this matter in public?
It's interesting. People will stretch it and ask you to what extent can't the public discuss it and what exactly are the stipulations of the Constitution. But sweetie.
Yes, and Mr. Pencil, I mean, aside that one demand for in-camera hearing or not, a lot of arguments pouring in suggest that the Chief Justice's move to go to the Supreme Court backed by lawyers is a, quote, provocation. And I'm quoting former director of Ghana School of Law, Kweku Ansasari. He said the move is a provocation that flies in the face of constitutional governance. To which he's saying that she should have gone to the Judicial Council, not go to the Supreme Court backed by lawyers. Help me understand what's going on here.
You know, I found Kweku Ansasari's commentary very interesting. I mean, I find it very interesting. You know, it is life is dictated by circumstances, by things that are going on. And I don't even understand Kweku Ansasari's position at all. Because her office is at stake. It is true we've got a General Legal Council that has got a way of resolving matters. But this is a case where the president has made moves that are intended to remove her from office. When the president has invoked that power of his under the Constitution, which may lead to her, removal from office, I'm sorry to say that if Kweku Ansasari's argument is to suggest that the Chief Justice ought to go to General Legal Council, I fear that there could be no legal basis for his suggestion at all.
In fact, he joins us on phone right now, and so let him respond to what you just said. Mr. Kweku Ansasari, thank you for joining the conversation.
Yes, madam. Welcome. Yes.
Is that Mr. Kweku Ansasari?
Yes, please.
Okay, we were just discussing the statements you made, I believe, yesterday on PM Express, describing the move of the suspended Chief Justice to go to the Supreme Court backed by lawyers as a provocation that flies in the face of constitutional governance. It doesn't appear Mr. Pencil agrees with you. Who just dropped the line? Oh, unfortunately. Mr. Pencil.
I am on it.
Mr. Pencil, go ahead. I wanted him to respond to what he just said, but he's dropped the line.
I really wish that he could defend his position with legal arguments. But
Right.
I can only say that the Chief Justice has not committed any error, whether in procedure or in substance of the law, when she invokes the jurisdiction of the Supreme Court to make a determination on what the President has initiated against her. If at all, at the end of the day, when the Supreme Court has delivered itself of its judgment in this matter, if for no reason at all, to serve as a precedent so that to guide us all of us as to any future course. Don't forget that this is the first time that there has been any move under the 1992 Constitution to remove the Chief Justice from power. And therefore, as far as the legal precedence is concerned, within our jurisdiction, I would say that it's without precedent. But what happens in what's going on will serve as a great lesson for all of us. So for that reason alone, I think that there is some basis for the Chief Justice's action.
Okay. And Mr. Pencil,
if you look at the initial bid in respect of an in-camera hearing, is there any breach specifically? Kweku Pencil, just give me a straightforward answer. Per the Constitution, is there any breach?
Any what?
Any breach of the law?
No, I wouldn't say so. You know, these matters, this is not the first time that a matter affecting in-camera hearing has come up where the public have already entered into the debate and so forth.
Right.
I was trying to recall one of these two cases, but I remember Justice Benning. He had delivered one of these judgments in which an attempt had been made to set aside the proceedings on the basis that the public had already determined the matter had prejudiced the hearing and determination. And Justice Benning, I'm sorry I cannot remember the exact case, but I remember this is not the first time.
Okay, Mr. Pencil, I'm sorry I have to interject. We're trying one more time to reach Kweku Ansah-Asare. Good morning, sir.
Good morning.
Okay, I can hear you, but faintly, but it's okay. Why do you feel that this latest process, as per Godfrey Abuadame, on behalf of the suspended Chief Justice, is going to trigger the committee or the Supreme Court? Why do you think that?
There's two reasons that Abuadame, as a former Attorney General, was Attorney General during the NPP era, and therefore everyone knows his political lineage, the NPP. Two, he was one of the key persons who supported the nomination and therefore the appointment of Deputy Chief Justice Torkonoo. You see, and therefore entering into this legal battle suggests that it is an NPP-NDC legal battle, and I think that as far as that picture gets painted, the ordinary Ghanaian citizen would think that it has ceased to be a legal battle, but has now become a political controversy.
Is it merely because? Is it merely because of his?
Behind the scene, and allowed some other lawyers to represent the Chief Justice. I'll not, have any problem with it. So the problem I have with it is that it is entrenching, the political divide. So it's now clear the lines are drawn. It is NPP, it is NDC. You see? And it was something that started as a legal battle, is now engrossed in a political controversy. It's not good for the nation. It is not good for the nation.
Right. You say it's not good for the nation. Godfrey Abuadame has said that he's standing in as counsel for her. I mean, he has the right to do that. In fact, he says it is erroneous to think that his role as Torkonoo's lawyer in the injunction application against the probe affects the optics. He disagrees with you. But beyond these optics, there is an issue of an in-camera hearing. Kweku Pencil has shared his thoughts on it. Per the Constitution, my reading of what Professor Azan and others have shared suggests that this is, per the reading, constitutional on the face of it. It's not optional. What do you think of that, the in-camera situation?
It's not optional. It's a constitutional fiat. So it is something, it is a hurdle, that cannot be, crossed. So once the Constitution has stipulated the proceedings, to be in camera, no one, can be taken out of them and, merely because the person is a Chief Justice, therefore the person can wait. How many ordinary Ghanaians, can we set right? If you or, let's say, my wife, were to find yourself in this controversy, do you think that you can appear before the committee to suggest to them that you have decided to waive your right and they will hear you? No. The law is no respecter of persons. The president is subject to the Constitution. The Chief Justice is subject to the Constitution. The whole Ghana is subject to the Constitution. No one is above the Constitution. The Supreme Court is not above the Constitution. Whatever we do must be in consonance with the dictates of the Constitution.
Speaking of that Constitution, we know when the Constitution uses shall, what it means. But at the same time, on the back of the same political context that you've made mention of, that it's become political, NDC, NPP. And again, the context. Does the context matter at all? After all, the law is supposed to be progressive, right? Is it high time we looked at that clause to determine whether people can waive their rights?
Well, you see, that is why over the years, the canons of interpretation, have increased from 2 to now 6. In the past, it was just the neutral rule of interpretation. So, the judges should become now constitutional constitution. But they realized that it was not healthy. If you take a strict constitutionalist approach, it may not help. They went on to the golden rule, and now they take a policy rule. What is the purpose, of Article 146 is in enacting that the proceedings shall be heard in camera. So if the word shall, had been used, there is no other, middle way. It is shall, and, shall is shall. Even though I concede that there may be instances where, the word may be construed. The 125 have, made it quite clear that citizens can, participate in the administration of justice, and we are participating in it. But the same constitution, says that when it comes to certain matters, such as the one, at hand, the proceedings shall be heard in camera. You have no choice. The Chief Justice, has been supervising the administration of justice. There is no situation which will call for a relaxation, of the word shall. This is not one of those situations. She has, boxed herself into a tight corner. These arguments, will not advance, the cause of action, any more than what it is already on the ground. And as I said yesterday, I see all these, moves as a ploy to frustrate the committee from proceeding to completion. But these frustrations aside, the judges are human beings. They are being provoked, and they will take it out on all the lawyers who appear before them. So the moment you apply for an injunction order, it will be placed. If I were the Supreme Court, all I would say is that we have made certain pronouncements. Enough is enough. Any new application shall abide by the pronouncements that we have already made. To bring an end, to this endless ping-pong game, you should take that tough stand, Now, the Chief Justice herself, she's now a litigant. Just once she appears before the court, is she going to bow before her own junior as a chief justice? The buck stops on her deck. Now she's lowering standards. She's going to appear before the very people she had a hand in appointing, my law, my lady, and all that. I mean, people will, people on the bed, they'll be laughing at her without her knowing. And I'm saying that this is not, what we ask for. We did not go, to court to be ridiculed or humiliated. But now that, the stakes are high, by virtue of what she has herself done, it means she has slammed the door behind her. She's taking the key away, even if the petitions succeed. She will find it difficult to reopen the front door to enter.
Just clarify for me, are you saying she's gone beyond the point of return with this interlocutory injunction she's seeking? Has she gone beyond the point of return?
Pardon?
Has she gone beyond the point of return with this latest interlocutory injunction she's seeking?
Sure.
Okay.
Sure.
All right.
She's closed the door.
Okay.
She's closed the door behind her. She cannot enter. When the committee was set up, the president, even though the president closed the door, he left the key hanging. And therefore, whenever the outcome was known and the petition failed, she would, merely, remove the key to open the front door and enter. Now that, she has sued the president, she's not sued the attorney general, she has sued the president. The only reason why she could not mention the name of the president on the writ is because of the immunity that the Constitution has accorded the president. That is, why she has had to sue, the attorney general. Otherwise, it's the president she has sued. But if you sue the president,
please,
who is, the head of one arm of, or branch of government, and you are also, when you finish and you lose, can you go back? And the state appeals to the good conscience of the president to reconsider his position, even if she wins. How is she going, to? She may go there, and the executive may decide, not to do anything about, the estimates of the judiciary.
Right.
The chief justice is constitutionally obliged to submit, the estimates for the judiciary, to the executive. Even though the Constitution in Article 127 has suggested that it should go straight, to the Ministry of Finance, for approval. They will still have to go through, the executive and then take legislative approval. So the independence, that has been enacted in Article 127, theoretically, yes, but practically, there's some diminution there.
Right.
So the independence, financial independence of the judiciary, since 1992, has remained, on paper. And now that, the Chief Justice of the nation has sued the executive, I don't think that all is going to be well. The relationship, has broke. It has never, ever repaired.